topic name is property law, and in this video what we are going to discuss, that is basically already we have discussed, but it is a sort of revision but very much important. It will further strengthen your the understanding of the properties and respective laws, and basically transfer of properties and the mechanism, provision and the rules. So you need to focus on the screen, that is the table, and in this table we will discuss one by one. So just check it out. It is a comparative analysis of mode of transfer of property. The first column, that is saying difference based on, that is basis, and then subsequent sale, lease, exchange, gift. So based on nature of transfer, how these terms are distinct to each other. Let's check it out. In sale, the nature of transfer is it is permanent and money is given against the property. Similarly, in lease, transfer of ownership, that is conditional and for the limited period of time. In exchange, transfer of ownership for some other property means you gave something and you receive something. As such, there is no money involved. We have discussed that. And lastly, the gift. In gift, ownership is transferred without any consideration. So it is done with free consent that you are giving something to someone. So that is based on transfer, basically nature of transfer. Now this second criteria, that is consideration, and I believe you must know what is meaning of consideration. Consideration means that is money. So based on consideration, sale involves money. Of course, one party is giving the property and the second one who is buying paying the money. In lease, the ownership is transferred, of course, for the limited period of time with some conditions. In return, the person is giving rent, and that is of course money. The third one is exchange, and in exchange no money involved. You gave your property and you receive others' property with mutual consent. In gift, no consideration at all. There is nothing. One party giving his or her property to someone without any consideration, with his or her free will. The next one is mode. What is the mode? What is the basis of transferring this property? The sale involves sale deed. You need to prepare a sale deed which has to be registered. Of course, we have discussed that. Secondly, lease. You need to prepare lease deed, though it is essentially not required, but if the lease period is more than a year, then it is essentially required, and before that it is optional. In exchange, sale deed is essentially required. In case of immovable property, in case of movable property, it is again optional, desirable. And regarding the gift, registered means whatever you are gifting out to someone, that has to be registered if it is immovable property. However, regarding the movable property of lesser value, the delivery of the product, the delivery of the thing that you are giving, maybe jewelry, maybe something like that, some electronic gadgets. So the moment you deliver, that is done. Lastly, based on liability. In sale, only one party at one time, provided there is no cheating. What does it mean? That at one point in time, only one party is responsible or liable of that property. Liability in the sense of the property. Who is responsible for that property? So seller, until he gives the possession to the buyer, till then he is liable. But once he gave the possession, so anything happens, then buyer is liable for that, whether it is benefit or loss. So it is buyer. So liability in that sense. In lease, it is conditional. Largely, it is the lessor or basically owner who is liable. But in certain conditions, even lessee is liable for some damages and all. But that depends on the condition and also based on the terms and agreements that you accepted while taking the property on rent. Next one is exchange. Only one party at one time provided there is no cheating. Means, as we have discussed in the topic exchange, that if you are exchanging something, so well, until you did it with your free will, no issue. But if you have been cheated by the other party because the product you have been given against your property is something like damaged and not good, as promised, as you have been informed, in that condition, the person who gave you, the second person who is at fault, will liable for the that damages, that loss, and you can get your property provided that property still lies with that person. If he had lost that by any means, then you cannot, but still you can demand or claim the damages. The last one is gift. That is, at one time one party is liable. Means if it is your property, you are liable. Once you gave it out, then who has received, that is donee, he or she will be liable of anything happen to that property. But still, cheating shouldn't be involved. Whatever the property you gifted, it's not like that you just hide some information regarding the liability attached with that property and later on the donee come to know about that. In that condition, you may be in trouble. So, but largely, if we see the overall, then this is how it works, and this is what, and this is the major differences between sale, lease, exchange, and gift. So, I believe now these points are much clearer with this table. So, watch it again and again to clear your doubt. So, see you in next video.